I would like to bring about this discussion today on the current scenario that we are in, the pandemic and the lockdown, and how this lockdown is flexing the legal system that we currently are having in our country. I will begin with the fundamentals. Let's understand what a pandemic is. The World Health Organization defines a pandemic as a spread of a new disease. Today, we are bogged down with the spread and rapid, unencountered spread of a new disease, the coronavirus. Now, what makes a pandemic a pandemic? Well, the impact and the severity of the disease and the number of people that it attacks simultaneously and consecutively makes it a pandemic. And this is also one of the reasons for this is the lack of pre-existing immunity in large populations of people, large sect of population of people. This is also the difference between a viral that is seasonal in nature and a viral pandemic. Now, coronavirus was announced as a global pandemic by the WHO on March 11, 2020. It quickly escalated to community transmission. And for this, WHO recommended certain measures of social distancing and isolation of potential carriers or infected patients. But in today's world of mass transportation, mass work sharing, mass dining, mass dwelling, mass worshipping, and mass thronging at markets, social distancing is actually reduced to two very literal words and offered as advice. Despite how much one would try, coming into physical contact by way of courtesy, innocent brushing, and or casual inhabitants is simply unavoidable. Unfortunately, despite many countries' governments putting up mass awareness campaigns about these WHO cautionary advices, we are at a staggering number of infected patients and fatalities. Restrictions have come in place internationally. They have been imposed, but they have caused mayhem in financial sectors, commercial and trade sectors, aviation and shipping sectors, medical sectors, and a plethora of other problems, of which the list is only increasing as we speak today. Domestically, however, the scene is much graver. Apart from our basket already being weighed down by the aforesaid problems that are currently being faced by mankind at large, India faces an ugly, disgusting, politicized and communalized throng of problems amidst this disaster, which is turning out to be a catastrophe. In a country where work is worship is worship, and discipline is routine, adhering to contrary for multitudes of people, even though through a governmental order, becomes unintelligible. People from all strides of life have disregarded this, and it has culminated into the dark day of the imposition of the unprecedented lockdown under the National Disaster Management Act. It was widely broadcasted as Prime Minister Sri Narendra Modi's address of creation of Lakshman Rekha at the threshold of our doors. Well, we need to understand and get behind the curtain of the lockdown. It was the day the country was introduced to the strict provisions of the National Disaster Management Act. It was the day when the country was introduced to the primordial Epidemic Diseases Act of the 1897. And what different powers are conferred upon the government of India through the Constitution of India. Now, while India witnessed a rising graph of infected individuals, the sovereign of India took the extreme measure of enforcing a 21-day lockdown. Prime Minister Sri Narendra Modi on 24th March announced a lockdown in his address to the nation. But intriguingly, the legal process only began after his speech had ended. Through an internal departmental communication of the National Distress Management Authority, an order through the chairman, who is the Honorable Prime Minister, was issued, making it the first time our nation was being clamped down under provisions of the NDMA. Please bear in mind, this is also the first time in the history of our country that a central government has issued directions of this magnitude to states at large. Now, one may ask, where did the National Disaster Management Authority, constituted under the Act, get such powers? Those powers are specifically contained in Section 6, subsection 2 of the National Disaster Management Act. For the sake of brevity, let me quote the section itself. And it reads as, subsection 2, the national authority may lay down policies on disaster management, approve the national plan, approve plans prepared by ministries or departments of the Government of India in accordance with the national plan, lay down guidelines to be followed by the state authorities in drawing up a state plan, lay down guidelines to be followed by different ministries and departments of the Government of India for the purpose of integrating these measures and for prevention of further disaster and mitigation of its effects. And last but not the least, it provides an opportunity to our central government to provide support for other countries that are facing a similar disaster. It is therefore clear that the unprecedented lockdown was a product of operations of the NDMA. Pursuant to invocation of the Section 6 of the NDMA, the Department of Home Affairs invoked its powers under Section 38, which giveth the powers to direct the state governments to comply with the orders passed under Section 6, subsection 2. These orders are strict and cannot be inconsistent throughout. Therefore, under Section 38, the Home Minister and the Department of Home Affairs issued orders for compliance of this lockdown. Now, argumentatively, the Honorable President, His Excellency Mr. Ramnath Kovind, could have declared a nationwide emergency under the Articles 352, 356, and or 360. But in my opinion, that would have made the situation counterproductive. It would have meant that all powers would have vested with the central government, whereas this is a situation where the state government's response from ground zero, the crucial place, is very critical. In my opinion, a combined force of the state government and the central government seems to be an efficient combination. It is only when states aren't cooperating or state government has been ineffective in implying or imposing certain measures that an emergency ought to be declared. This is not the case. In Maharashtra, we have our Honorable Chief Minister, Shri Uddhav Thackeray, who has been doing timeless efforts, who has been putting timeless efforts into making a safe locale for us and our people. Now, the lockdown has been imposed. Discussing whether it was procedurally sound does not matter, as that ship has sailed. Policies under the NDMA are brought in for the interim immediate situation. I agree, the current pandemic feels like a mid-April's afternoon, hot and here. But as seasons change, yin and yang, this too shall pass. The discussion, however, truly lies in how can one nation stay under a lockdown under the National Disaster Management Act, and for how long? The nation which is still guarded by the pillars of law and which do not break the limits of flexing the legal system. Now, you hear me constantly talk about a legal system or a legal framework, and you would ask me, what does the legal framework actually mean? Let us dwell into the understanding of the legal framework. A constellation of laws that regulate, govern, and supervise our day-to-day life in the country, state, city, area, lane, our homes, right down to the individuality that you and I hold would constitute the meaning of a legal framework. It is always important to understand that the law encourages the people to do the right thing. The great philosopher Aristotle once propounded that people needed the discipline of law to habituate them into doing the right thing, from which standpoint they could then appreciate why doing the right thing was the right thing to do. It is also an established principle that no man is punishable or can be lawfully made to suffer in body or in goods, except if there has been a breach of law, and no man is above the law. This is the rule of law. It shows the paramountcy of law over any government. It is the first nail in the framework of the legal system. The legal framework is more like a living being. Some parts of it remain the same and rigid right since birth. However, some parts of it evolve with the growing society it nurtures. Just like the size of our eyes, they remain the same from the time we are born till the time we are returned to the dust. Similarly, protection of moral and rejection of immoral shall always be rigid in a legal system. Coming back to today's times of turmoil, the changes required in this time of the pandemic also require operation of law. Let us take a deeper look into what would actually form the legal network or the legal framework during this time. The legal framework after the rule of law is strengthened by the four pillars of foundation. The four pillars of the foundation are the preamble of the Constitution, the load bearer, the ombudsman of the legal system. Thereafter is the golden triangle rule. The golden triangle rule, which embodies articles 14, articles 19, and articles 21. It is called the golden triangle because they contain our fundamental rights. Fundamental rights and rights which cannot be detached from an existing living being in the sovereign of India. It is not necessary that these rights ought to only apply to a citizen. They apply to any individual who resides within the jurisdiction of our country. As you all might be aware, that articles 14, 19, and 21 have been widely looked at by a plethora of legal fora. At the apex, the Supreme Court, in a plethora of judgments like Menaka Gandhi versus Union of India, the great Kesavananda Bharati versus Union of India, are judgments which elucidate what the preamble and what these articles actually mean. Equality before law under Article 14 cannot be denied to anyone within the territorial limits of India, regardless of race, caste, sex, or religion, or place of birth. Article 19, which gives you the freedom of speech and how we are here today, freedom of expression, to assemble peacefully without arms, to form associations or unions, to move freely through the territory of India, to reside and settle in any part of India, and to practice any profession and carry on any occupation, trade, or business. And finally, Article 21, the romance with Constitution begins with Article 21. Protection of life and personal liberty. No person shall be deprived of his personal liberty except according to the procedure established by law. Each breath that we take in the city, in the country, in our homes, at the road, at the mall, at the theater, is governed by Article 21. We have our liberties under Article 21. Now, these are the forebearers of the four pillars. What form the strengthening part? The Indian Penal Code and the Code of Criminal Procedure together form the remaining two pillars of the four pillars. The Indian Penal Code is the order in the law and order. It restricts citizens and individuals in the territorial limits of India from committing certain acts. These acts are termed as offenses. This is immoral acts which are against the very fiber of the society. And lastly, the Code of Criminal Procedure, which describes that if any acts are conducted under the IPC, committed under the IPC, there is a machinery, enforcement agency, which has the powers conferred to prosecute you, albeit under the Constitution of India, safeguarding fair and proper trial. While the preamble, the IPC, and the CRPC are more or less stern and rigid in their scope of formation, the provisions, as I mentioned earlier, in the Golden Triangle are evolutionary and revolutionary. With reasonable restriction procedure established by law is always a caution. And mind you, that itself is also evolutionary in nature. In the current times of the lockdown, it is not beyond us to understand that a restriction has been imposed on free movement throughout the country, on free movement as such, and to assemble peacefully, guaranteed to us under Article 19, 1B and D. These restrictions, however, have been brought into force for maintaining public order and the interest of the citizens. To open the Pandora's box, the term lockdown itself is not legally a defined terminology. It is being propounded by the government in force today to govern and supervise a situation where free movement of goods, only mentioned as essential items declared by the Government of India under sections 2, 3, and 4 of the Epidemic Disease Act, are allowed. But still, one may ask, what is lockdown? Is it not the same as curfew? Well, one of the foremost differences between the two is that in a lockdown, state enforcement authorities like police cannot arrest persons for not following the lockdown without the permission of a competent court. A lockdown, however, can be imposed through the mechanism provided under sections 188, that is disobedience to the directions given by a public servant. Sections 269, that is a negligent act committed to spread infection of disease dangerous to life. And section 270, that is a malignant act likely to spread infection of disease of dangerous to life. These are sections that are contained in the IPC. Well, curfew again is not a legal term. Generally, exercise of power available to the district magistrate or any other executive magistrate under section 144 of the Code of Criminal Procedure in common parlance is considered to and referred to as a curfew. Although in a curfew, in these circumstances, for preventing danger to human life or disturbance of public tranquility or a riot or affray, the magistrate may issue orders under section 144 CRPC, which gives the police machinery the right to detain and arrest the violators of the curfew. So this was a beginning of what the lockdown means. Now, the lockdown is a homogeneous mixture of multiple laws. It's not just one law that has been invoked for bringing into existence such a lockdown of a magnanimous magnitude. Another act that contributes to a successful lockdown is the Epidemic Disease Act of 1897. This ancient fossil act was at one point of time most hurriedly drafted to stonewall the bubonic plague that devastated life in Bombay, as it were, in 1896. This plague had forced people to migrate out of the country. And this statute brought in provisions to stall such kind of migration because it would have led to further spreading of the plague. Interestingly, this statute only has 4 provisions. Sections 2 and 2A of the Act allows the government to take measures if it is satisfied that any state or any part thereof is visited by or threatened with an outbreak of any dangerous epidemic disease. Here, it is the coronavirus, and the part thereof is the entire country of India. If the government thinks that the ordinary provisions of law are insufficient for the purpose, then it may take or require or empower any person to take some measure and by public notice prescribe such temporary regulations to be observed by the public, including stalling of travel by air, stalling of travel by railways, stalling of mass public transportation, stalling of public gatherings beyond a certain limit, and detention of any ship, vessel, as the case may be. Now, Section 3 of this Act prescribes a penalty for disobedience of these regulations. Section 188 is the arm that it uses to penalize violators. A general example of a notification, public notification under the Epidemics Diseases Act would be the various states' notifications that have been making the state restrict movement in parts thereof, or offer work from home possibilities. These are measures that have been invoked under sections 2 and 2A of the Epidemics Diseases Act 1897. Now we come to the third protagonist of the lockdown, as I may call, the Disaster Management Act. The Disaster Management Act provides the administrative framework to take measures to deal with a disaster in any area. Now, originally, this act was brought into existence, I beg your pardon, was brought into existence to deal with disasters arising from natural or man-made causes, or by accident or negligence, which resulted in substantial loss of human life or human suffrage, or damage or destruction to property or degradation of environment. As such, the Disaster Management Act ordinarily would not apply to COVID-19. However, on March 14, the Home Ministry declared coronavirus outbreak as a notified disaster, thus bringing to the play the provisions of the National Disaster Management Act. This notification of COVID being declared as a notified disaster has allowed the National Executive Committee to give directions to the government to take measures, and has delegated powers to act under the Act to the Union Health Secretary. It further allows usage of disaster funds created for this purpose. If I may say, this act has more teeth to deal with a disaster situation and includes power to imprison and fine, etc. The act also has a means to control social media and the information that circulates on it. The act has been used in tandem with Epidemics Diseases Act, with the latter providing the basis for containment of and isolation and quarantine, and measures such as restriction on flights landing in India, taking off from India, prohibiting gatherings, as I mentioned before, and various other measures adopted since the outbreak. Well, as much as I say that there exists a legal framework, there is a definite need for a legal framework for regulation and regulating the availability and distribution of the vaccine once it is found, and the drugs and implementation of the response measures. Now, from what I have been saying, it is clear that no single law can effectually control the present outbreak. It is this reason that you will find various provisions of the Indian Penal Code, Criminal Procedure Code, the Epidemics Diseases Act, National Disaster Management Act are being invoked to control the current outbreak. Despite this, one may ask, what is the constitutional validity of the lockdown? Now, the constitutional validity of this lockdown stems from an article, that is the Article 245 of the Constitution of India, which states that the Parliament or the central government has the power to make laws for whole or any part of India, and the state government may make laws for whole or any part of the state accordingly. While Article 245 envisages the basis for division of power, Article 246 provides for the distribution of legislators of subjects between the union and the state governments. This is achieved by the introduction of 3 lists merited in the 7th schedule of the Constitution of India. The 3 lists that are the union list, state list, and concurrent list. From their nomenclature itself, it can be understood that the union list lays down the subject matter on which the parliament or the union government has exclusive power to legislate. Similarly, state list provides for matters on which the state government has an exclusive power to legislate. And lastly, the concurrent list provides for subject matter on which both governments can legislate. Constitutionally, the state government is empowered to deal with matters related to public order and public health, listed in the state list, entries number 1 and 6, respectively. However, intriguingly, entry number 29 of the concurrent list empowers the central and state governments to legislate on matters pertaining to the prevention of an infectious or contagious disease spreading from one state to another. The entry does not limit the powers of legislating authority to simply public order or health, but allows any relevant legislation to be passed so that it can prevent the disease from spreading from one jurisdiction to another of a state. Since both central and state governments are empowered to legislate on an entry, a conflict of policies cannot be ruled out. Addressing this logjam, the constitutional draftsman introduced Section 254. Let me reproduce Section 254 for your understanding first. Inconsistency between laws made by the parliament and laws made by the legislatures of the states. If any provision of law made by a legislature of the state is repugnant to any provision of a law made by the parliament, which parliament is competent to enact, or to any provision of an existing law with respect to one of the matters enumerated in the concurrent list, then, subject to the provisions of the clause 2, the law made by the parliament, whether passed before or after the law may be made by the legislature of such state, or, as the case may be, the existing law shall prevail, and the law made by the legislature of the state shall, to the extent of the repugnancy, be considered void. I beg your pardon, Article 254 enshrines the doctrine of repugnancy. This doctrine was well explained by Honorable Supreme Court of India in the famous case of M. Karunanidhi versus Union of India. It observed where the provisions of a central act and a state act in the concurrent list are fully inconsistent and are absolutely irreconcilable, the central act will prevail and the state act will become void in view of the repugnancy. Therefore, the Constitution acknowledges and foretells the paramountcy of parliamentary law. The DMA, or the Disaster Management Act, was a parliamentarian law that was passed in 2005 to enable the central government to provide a legal framework for setting up of a national disaster management authority under the chairmanship of the Prime Minister of India and not more than 9 members nominated by him. The powers conferred upon the authority can be broadly interpreted to give a unified command to the central government to effectively manage a disaster throughout India. Going by the current scenario, the COVID-19 outbreak is bound to be classified as a disaster under the DMA 2005. And as I previously mentioned, it has. Allowing the central government wide berth to deal with the pandemic by laying down policies, plans, and guidelines to ensure a timely and effective containment is the current requirement. This brings me to the conclusion of today's conversation. Concluding this discussion on whether the lockdown fits as a piece of puzzle or not, is valid constitutionally or not, is lessened by what I believe is a Latin maxim that I'm reminded of. The maxim goes as salus populi suprema lex, which means that a law made in the true welfare of the public at large is the supreme law. We cannot let go the flexibility that the legal system has taken in towards the current scenario. While I was discussing this with my fellow advocates, Advocate Vikram Kamath and Advocate Ehtesham Thawer, who are also with us today as attendees, the courts have shown flexibility towards the welfare of public by becoming video conferencing courts. The courts have shown flexibility by bringing in facilities in filing. But there is a contra side to that. Despite this flexibility, there is concurrency of orders causing confusion. Looking at the state of affairs, if we are in this for long, there is a dire need for uniformity of authorities. But like I said, the lockdown cannot be constitutionally challenged. Always remember, Salus Populi Suprema Lex. The meaning and the fabric of this maxim resonates with our preamble, resonates with the golden triangle, and of course, resonates with the attempts that the government is currently taking at containing the spread of this virus. As subjects of this government, I believe it is our right and duty to check the government and validate its policies through judicial intervention. But in times like these, dire times like these, I would like to close quoting a famous philosopher and a lawyer par excellence, Adlai Stevenson, on governments. Public confidence in the integrity of the government is indispensable to faith and democracy. And when we lose faith in the system, we have lost faith in everything we fight and spend for. Thank you for giving me this opportunity to be with you. I shall open the floor for questions, if any. I have two questions before me on the chat. Arnab Biswas and Taiba Khan. And now one from Devang Singh also. I will go in the order of how they've been asked. Arnab asks, during this unfortunate situation, one of my friend and client is stuck at Netherlands. She's a resident of Pune, Maharashtra. She has lost her job and has filed for unemployment benefits, which is only available for 3 months for her. Government of India has disallowed landing of any international flight from 18th of March to 14th of April. It is likely to get further extended. And in this situation, while she has no option but to pay rent every month and unable to travel back to India, at this situation, I am planning to file a writ of mandamus for violation of fundamental right of hers as guaranteed by under Article 14(19)(1)(g) and 21 at Bombay High Court while making party of the Government of India, Government of Maharashtra, Ministry of External Affairs, DGCA, Embassy of India at Netherlands. I want my client who is not yet infected by the virus to get airlifted. Well, I will answer this live. Arnab, the procedure that you have adopted or you choose to adopt is the right procedure. However, in my opinion, people are being airlifted when they approach the Indian embassy in their respective jurisdictions personally also. I believe if that is not a viable solution, then yes, the writ will be the correct procedure. And the only additional advice would be that you will have to show that there have been attempts taken by the government to airlift people, which is the case. You will have to show that these efforts can be taken in case of your client also. I hope this answer was satisfactory. You can always get back to me on the contact details that I share at the end of this session. Taiba Khan asks me a question: can a person be charged with sedition for not following the law during an epidemic? Sedition is conspiring against the country, which is narrowing down an act too much. If one person is caught that is deliberately causing the virus to spread, there are, as I mentioned in my talk, there are other provisions which can be invoked. Sedition is only if there is a rebel to the government in terms of turning it down. So I believe, in my opinion, in my limited experience and practice, and in my opinion, I believe sedition cannot be charged, although I'm open to further opinions. Devang Singh asks my views on the police brutality in these days. Yes, the police brutalities are of concern, but there are two ways to look at it. Uh, as much as we do call them a police machinery, we must not forget that they are also citizens of India, and that they are also prone to the spread of this virus and are susceptible to this virus. While we are in our homes, in safe environment, police out there is day in day out taking attempts to keep us safe. Frustration is a cause of police brutality. Now, the only way frustration can be taken care of is by cooperation. I believe if we cooperate with the police machinery, the brutality will reduce. However, Supreme Court has taken cognizance of these brutalities and is taking measures by imposing guidelines on the functioning of police. Ria Makwana asks me, do you think there should be also do you think there should also be measures to be taken for filing and listing of matters once the lockdown is over? That's a very interesting question, Ria. What is happening currently is that uh, we are not sure of what the situation of the lockdown is. But in time, when the lockdown is taken down, there are attempts, there are discussions going on in various legal fora, be it the High Court, be it the Supreme Court, to streamline this roster and streamline filing of matters. It's only in due time that we'll get to know how efficient it is. Siddharth asks me two questions. What is essential service identified? Siddharth, if you look at the Epidemics Diseases Act sections 2 and 2A, it defines, and the further notifications under these act that the state governments have published, you will get what the essential services are. However, for the brevity, I will let you know in short here: medical services, essential groceries, essential trade commodities, for example, machines that are required for propagation of and manufacturing of medicines, medical equipments. Police is essential service. Ambulances are essential service. Public transport to a limited extent is essential service. The Disaster Management Act order of 24th March, which was ratified or incorporated by Maharashtra government through their order, has prescribed how many passengers can there be in a commercial public transport. In place of 3 in a rickshaw, they have said that only 1 can be seated apart from the driver. In a taxi, 2 can be seated apart from the driver. In a bus, 11 can be seated apart from the driver and the conductor. So these are essential services. There is a long list. I could share the PDF with you later. Whether the second question that Siddharth asks me is whether any clause can be invoked in Contract Act of God. Well, this is like a $1 million question, and a cause of litigation that is going to be in the limelight for quite some time. Force majeure, act of God, vis major, all depends on what the contract was, how these clauses were worded, and how much of the contract has already been performed. If the contract has not been performed or initiated, it then becomes a frustrated contract. If you cannot, because of the circumstances that are prevailing, you cannot perform the obligations, it becomes a frustrated contract, and therefore you need not invoke the act of God clause. However, partially performed contracts, force majeure is an arguable situation. One may take a shelter by invoking it. I'm sorry, but the other party to the contract may well protest and dispute this. Devang also asks me, how are persons being arrested mostly for violation of Section 188 for violation of orders being presented before the magistrate within 2 hours? I'm sorry, I've not understood. How are persons being arrested mostly for violation? Section 188, as I previously mentioned, is violation if you disobey the order or direction given by a public servant. A public servant may be the commissioner of police. Public servant may be a person that is notified or prescribed under the various acts that I mentioned by the government of India or the state government respectively. Disobedience would therefore make you a violator and be eligible for you for one to be detained and arrested and thereafter be taken under the criminal procedure code for remand. Wasim Hassan asks me, the courts are adopting video conferencing. Do you think this would continue post the pandemic as well, since the pandemic is forcing the legal system to be adopting technology? Wasim, this is a very, very nice question. And I would all urge you to look at, to take time out and hear Senior Advocate Supreme Court, Dr. Abhishek Manu Singhvi, give his opinion on this. As much as one would take this up perfunctorily, I believe that, now this is my view, that as much as adoption of technology is towards making egress to courts easy and accessible, I believe that it will still have its limits, it will still have its impediments, and eventually, as a lawyer, I would say nothing can change a judge's mind as a lawyer in a courtroom with his will, with his determination and voice and conviction can. So I'm not really a propagator or a propounder of this technology being adopted. However, for required reasons, if it may, I will be very happy. Pooja asks me a question. What is the section for punishment for the person who is taking deliberate measures to spread the disease? As I mentioned, section 269 and 270 of the IPC are the relevant provisions. They take under a malicious or malignant act or a negligent act and accordingly penalize you for that. Reha M, I believe, is asking me a question. What is the constitutionality of validity of orders issued by the HRA and the state governments directing private employers to make the payment of wages and the salaries to all laborers? This actually emanates from Section 6 of the National Disaster Management Act. They are not per se making orders. If you read the notifications clearly, they are directives or advisories which are to be adopted as much as possible in one organization. As much as, if you recall our Honorable Prime Minister's address on the 24th of March, he appealed to all employers to take this stand. However, if there are any orders which I have not mentioned, I'm open to discussing on them once I've read through those. Thank you. Vidhi Joshi asks me a question. What to do if the employer deducts the salary for being absent during the lockdown period? Are there any guidelines issued by the government for the same? Vidhi, this question is interesting to a very generic situation also. This can be taken up depending on your stature of appointment in the organization, in your questioned employee organization. You could take it up with the Industrial Disputes Act or a relevant employee dispute redressal forum, even today. Siddharth again asks me, what will be the limitation period and when will it start in this scenario of COVID? Limitation has been very, very recently dealt with the Supreme Court of India and has been and has very exhaustively laid down that the period of lockdown will definitely be not considered in the period of limitation. Now, this lockdown, we are unaware how long it will last, and therefore that period of limitation also then therefore resides in limbo. Nilesh Maskar asks, any maximum time limit for lockdown under the Act? That's a very nice question. Nilesh, the National Disaster Management Act uh, allows for a national plan under Section 11. Now, this national plan is obviously to mitigate the consequences of the disaster. This national plan is to build capacity to come back to normalcy, and the state government and the central government together have to form state plan and national plan respectively, which are both revisable annually under the Act. Therefore, you can't say that the validity uh, is how long can it be or what is the maximum time. However, there will be revisions to this lockdown period, and uh, there will be revisions for periods for how long the lockdown can be imposed and can be released. What if the lessee doesn't pay the rent? An anonymous attendee asks me during the lockdown. Well, if the lessee does not pay rent during the lockdown, you're supposed to ask him why first. I mean, that's my general notion. But if he does invoke uh, any particular excuse or reason or justifiable reason that relates to the lockdown, I will remind you again of the appeal that our Prime Minister, Mr. Modi, has made to accommodate in the current scenarios. Another question that I'm asked is why COVID Corona-19 pandemic has not been declared as a national emergency. I dealt with it actually in my talk. The national emergency would mean vesting and centralization of powers, which, in my opinion, is not optimistic and not optimal currently. You would require states to take immediate measures, despite there being national plan, a state to take immediate measures if the graph of infected people, the curve as it is known, exponentially increases. Also, the Vandana asks me, "Oh my, I hope I'm not too slow. If it is required, I could type the answers. Uh, let me know." Another question that comes by is what will be further action plan for aiding economic revival? Aiding economic revival, like I said, it's beyond me to answer this question right now, but there will be plans because the NDMA does bring out these plans. There will be measures taken by both governments. There will be incentives. Recently, if you recollect, the income tax department has brought in an advisory that refund up to 5 lakhs will be made immediately. So there are measures being taken. It's only we have to give them due time. Vandana asks me a question: what if a person is arrested for violation of the orders under Epidemic Act? Can he avail bail? Vandana, this reminds me of my law school days when I had asked a question, when can you avail bail? And my professor had answered saying, bail is not a privilege. Bail is a right. Thereafter, jail is a deterrent and jail is not a directive. Therefore, bail is always an option. It's just the magnitude of the offense that is committed that will depend on when the bail can be availed. Rajan asks me, there are instances of ostracization of families with infected members. How do we counter such ostracization? countering this ostracization in the current scenario, in my opinion, is a difficult task. I believe that it would require some legal pondering. It would require some logic and brainstorming before any measures can be taken up. But under the Epidemics Act, isolation and quarantine are legal and valid principles, and ostracization in towards isolation or quarantine currently is legally viable because the provision has been invoked under the Epidemics Act. Therefore, this is a gray area. Rampant and irrelevant ostracization could be checked again by approaching and invoking the writ jurisdiction before the Bombay High Court. But otherwise, I'm not too sure currently is the time. Harshvardhan Singh asks me, can a magistrate under section 144 issue shoot at sight orders? Is it constitutional? Under what conditions? I'm sorry, but I'm bogged by this question. Shoot at sight is never an option. The Constitution does not allow it. Principles of natural justice do not allow it. Audi altrum partem is one thing that must always be borne in mind, that the other side must be given a chance. But since the question is asked, let me ponder on it and talk about its legal validity. In my opinion, limited practice, limited experience, I believe no. We are a democracy. We are not a dictated state. Therefore, shoot at sight orders, in my opinion, cannot be issued. Vaibhav Rajam asks me, after the end of this pandemic, in your opinion, or I believe it's option, is there any necessity to introduce any new laws or amend current laws? Yes. If you realize, I've mentioned that an act which has been brought from the archives of the archives, a fossil act of 1897, that itself needs not just amending, but it needs restructuring, it needs renovation. In my opinion, it absolutely needs to be repealed, and a new legislature, a new statute looking at the current scenario of the society needs to be drafted. And in my opinion, it soon will be, once normalcy is in. And what kind of laws? Well, laws that help in containment, isolation, in propagation of such lockdowns, God forbid. The sky is the limit in what kind of laws can be introduced. Apeksha asks me, what exactly is the difference between a lockdown and a bandh? The second part of the question is, many of the agreements contain the word bandh in force majeure clause. Do they mean the same, or there is a thin line of difference? Apeksha, it's an interesting question. Like I said, we are a country that is politicizing every matter. A lockdown in the current scenario has emanated from a constitutional statute giving constitutional powers, giving constitutional powers to the Prime Minister, the various departments of the central government, the various departments of the state government. Therefore, the lockdown in the current scenario is a valid situation. The bandh, on the other hand, is a call of redundancy, if I may, is a call by clans, goons, and protesters. The force majeure clause includes the word bandh because at times normal life is affected, and performance of obligations under a contract may be affected, thereby causing irreparable harm or sorts, and therefore they contain the word bandh. There is no line of difference. Bandh is legally unsound. Lockdown in the current scenario seems sound enough. I'm asked another question: what rehabilitation and aid can be given to the vulnerable sections of the society and migrant workers? Interesting question in the current scenario where we have throngs of both. Section 6 of the National Distress Management Act, again, National Disaster Management Act, I'm sorry, again, empowers the state and the central government to take measures for these issues also. It's only in time what policies are made that we can discuss on this. What rehabilitation and aid can be, there is a relief fund. There is always a relief fund under the Disaster Management Act. Despite that, and quite questionable in my opinion, is an introduction of another relief fund called the PM CARES. However, both these funds are being utilized towards harmonious integration of measures to contain coronavirus and provide food and rehabilitation. Therefore, these funds are the correct and current rehabilitation and aid given to the vulnerable society. Vandana also asks me whether the Epidemic Act passes the test of reasonable restriction on fundamental right of privacy of individual. Vandana, in my opinion, the Epidemics Act does not intrude your privacy per se. It only restricts your movement currently. In fact, you have been detained to your private self by the invocation of this Epidemic Diseases Act and the provisions under that. But if you say that does it pass the test of reasonable restriction, you must go back and think of the maxim that I said, salus populi suprema lex. Give that a thought. In my opinion, it does pass the test, maybe marginally, maybe for a while, until proper measures are not in place. But currently, yes, they do. Karishma asks me, since our offices are physically closed and most of us are working remotely, in view of this, any notices sent out during this period would be valid. Karishma, this question actually takes me to effective service of the Civil Procedure Code. Notices are to be effectively served upon the noticee. That would require a proper acknowledgement. In today's times of digital media, the Bombay High Court in several judgments, the Supreme Court in several judgments have even accepted service of notices, service of summons to that effect via WhatsApp and email. But if a physical service of a notice has been made in absence of other attempts, it can be challenged as unreceived and it can be deemed invalid. However, if you have received it through any other electronic media, it can be considered as a valid notice. Nirali asks me a question. In light of COVID-19, can employers force employees to go on paid leave? Well, I'm sorry, I'm taking time. This involves some thought on people who dwell on employment laws. But I believe that forcing is much less a situation here because it's more of a government advisory. So thank you, government, in that case. But yes, if the government has directed it and the employees are not abiding by it, the employers can force it. Can force it. uh, Anonymous question again. Isn't it against the public interest that the prisoners are being released as a precautionary measure for COVID? Well, interesting question. You have to realize one thing, that once a criminal need not always be a criminal, although once a convict always remains a convict. We follow the reformative system of punishment, believing that uh, some of these prisoners which are being released or which may be released are being released upon screening of behavior. Some of these, uh, in my opinion, would be entitled to a bail or a parole. And again, uh, being against of public interest, today public is not in a public place. Today the public at large, by large, is in their own private homes. The courts have advised, motivated the center to take a stand on decongestion of prisons. And that was a situation prior to COVID-19 also. It only was brought to light in the COVID-19 because of certain measures that were being taken in expediting those processes. Uh, in my opinion, since you asked, isn't it against the public interest? I would say it is not against the public interest entirely. And these prisoners are not released. Their sentences are not commuted to release, but are currently given a parole, in my opinion. Another anonymous question I am asked is, can the government force a person to work during the lockdown? For instance, if the medical staff falls short. Uh, if you are not a medical practitioner, the government is not going to force you to take up medical work. I believe this question stems from the countries where the government calls upon civilians to join in the cause during wars. Correct me if I'm wrong. Uh, by God's grace, India will never fall short of manpower. Uh, thereafter also, qualified medical staff is a questionable situation, but the government cannot force. But yes, if you are a qualified medical practitioner or qualified to assist medical staff, I believe you should stand up before the government needs to uh, force you, if it needs to at any point of time. Siddharth asks me the question, is the state liable to provide employment compensation to private sector employees who are sacked in this lockdown under the COVID-19 loss caused to them? No, the state is not valid. The private employer, if he may and find it fit, would offer compensation. Since you're using the word sacked, I would mean that it would involve some misconduct on part of the employee. Otherwise, in my opinion, again, referring back to the appeal, employers have been asked not to not to uh, retrench, not to release employees from employment in the current difficult times. Pooja asks me, essential services must be provided for free and light bills must not be charged for 3 months. Such an appeal was filed in the High Court, but no order has been issued yet so far. So what further steps must be taken, as a lot of people are facing financial crisis in this situation? Pooja, that's a very valid point. I am aware that this is still sub judice, but these are policy decisions. They ought to be, yes. Whether they can be and to what extent, remains to be a question answered. Remains to be a question answered in due time. Uh, I am unfortunately not entirely qualified to discuss this with you because A, I do not make policies for the government. B, I personally am not a party of to that appeal or petition for that matter. So I'm not sure as to what are the basis that they are uh, seeking this relaxation on. And finally, my understanding is that we as a country are too vast for such kind of extreme measures. Relaxation, reduction, incentives are possible, but entirely free of cost to 130 crore people seems a far-sighted situation, in my opinion, for a government. I'm open to discussion. I may be wrong. I may be having part knowledge in this situation. I would be open to discuss this further. Apeksha asks me, what relief will the lesser get since the lessees are now refusing to pay the rent? Well, there can be no relief per se. In my opinion, it's at most approach the court for imposition of some interest because it is a loss on part of the lesser also. Uh, but in my opinion, it's a case by case basis that must be viewed on. Every dispute that has arisen during this lockdown must be viewed on a case by case basis. There cannot be a generic order, there cannot be a generic understanding on any of the disputes to resolve them or to bring them out of an equilibrium. There are some questions which I have already answered. I'm dismissing them. They deal with extension of the lockdown period. Like I mentioned, it's a national plan. It needs to be reviewed annually. Interim, it can be, the policies can change. Again, I'm asked about the police brutality. There is current situation where they are being legally viewed and remedies are being brought in by way of guidelines. Uh, Sumedha asks me, what happens if a parolee violates conditions of a lockdown? Will it be considered as violating the conditions of parole? Now that many are released, well, conditions of the parole and conditions of the lockdown are definitely going to be different. And if he violates the conditions of the lockdown, he can be prosecuted for that. Article 20 of our constitution and 21 in that matter also brings in that there cannot be double jeopardy. You cannot try an individual or a criminal or an accused for that matter for the same offense twice. There cannot be self-incrimination. So in my option, a parolee, if he violates the conditions of the lockdown, can be charged separately for those offenses.